CIRP is running against the principal debtor, corporate debtor, can we initiate the personal insolvency? Because you will also appreciate that, see, we don't know what amount will be recovered from through CIRP. And at the end of the day, a lender cannot recover more than whatever has been claimed. A CIRP is running, we don't know what will be the amount that will be recovered from the principal debtor. Now they are also initiating. Is it fair? Is it possible? First of all, I'd like to know legally whether it is correct that the surety, the personal insolvency against the surety can continue while the CRP is parallelly running.
So as Ria has correctly told that the CRP, the personal insolvency resolution process can be initiated even prior to the CIRP of the CD. I must say that it is allowed legally, there is no problem. While a CIRP against a CD, the principal borrower is being carried out, while during that CIRP period itself, a case can be initiated against a personal guarantor or the corporate guarantor of the same CD against the same debt. What is debarred, what is not allowed is only the double debt. That what do we mean by that? Double dip is that we cannot recover more than what we have lent and for the amount of debt. So the amount of debt remaining the same, one cannot recover. If you cannot recover that from a CIRP, from a CD or an RA in a particular process of the CIRP, you are allowed to have to carry out the action against the guarantors to cover the remaining part of the debt, which remains unpaid even after the complete process or even prior to that process. So what is debarred is the recovery of more than of the amount more than what you have lent, but not the recovery proceedings. They are not barred. So you can either initiate a case against the guarantors prior to CIRP, against that principal borrower during the CIRP, or even after the plan is approved. So this has now been settled, well settled by various judgments also, that recovery from the guarantors and personal initiation of the personal insolvency against the guarantors can be initiated at any stage.
And this brings a very important question relating to again to the CIRP itself. For example, if I can my total debt claim is 100 crores, I could recover, and against both I have started initiated the resolution. I got 20 crores out of that from the personal guarantor. Now, would I be going back to reduce my claim in CIRP to 80 crores?
I think in case the entire resolution, the repayment plan by the personal guarantor has been implemented successfully, and you have actually received the payment, then you must file that and update that in the existing recovery proceedings against the same principal borrower, because the same debt has to be, the amount of debt has to be then updated over there. And in your claim, in the resolution plan, in the IM, everywhere that update has to be made in that running process.
Definitely, but definitely there will be some conflict can happen if the timings are same. There is a possibility. I think everybody will agree that there will be a possibility that if simultaneously the process is running, there is a possibility that the resolution plan is also getting executed, the repayment plan is also getting executed, and there is a dilemma to ensure that the amount should be recovered. That should not be double dip, or the excess amount should not be recovered. And we are not sure whether it will be recovered or not. But then maybe in future
the process has just started, sir. We'll see many more practical challenges going forward. So
exactly. That's why I'm saying the practical challenge.
Being clarified. Yeah.